state is being represented today by Mr. Brian Trammell and Mr. Steve Herzog, and that the defendant is present in the courtroom along with counsel Mr. Curtis Smith. What we have pending before the court today is a change of plea and a sentencing. The court will take note that we are conducting court in courtroom 301 as opposed to my normal courtroom 114 due to the fact that the court anticipated that there would be several individuals present for watching this particular hearing, so we tried to accommodate that the best that we could. All right. The court will note for the record that this case was initially charged as a felony. The court will note that on May 19th, 2023, the state filed a motion to amend the information that had been previously filed. Judge Nafs granted the motion to amend on May 23rd, 2023. An amended information was filed by the state, and the case was amended to a prosecuting attorney's information charging Ms. Goody with one count of battery, cause bodily harm, a violation of Idaho Code Section 18-903, punishable up to 6 months in jail and or $1,000 fine, and then there's a factual basis that is included in the amended information. Count 2 is battery, cause bodily harm, of also a violation of Idaho Code Section 18-903, punishable up to 6 months in jail and or $1,000 fine, or both. And then once again, there is the factual basis for the amended information and the count below the count 2 portion. When this case was converted to a misdemeanor, the district court, Judge Nafs, remanded the case to the magistrate's division, so that is why we're pending here today. Now, the court will note for the record a couple of things for the record. It did receive 2 ex parte letters that were emailed directly to the court. The court did not read those, as the court finds that those would have been inappropriately presented to the court prior to coming into this sentencing hearing. The court forwarded both of those emails to both the state's attorney and the defense attorney at the direction of the clerk. The court will also note for the record that the court received 30 pages worth of letters in support of Ms. Goody. The court does feel that those are appropriate to review in preparation for today's hearing, and the court will note for the record that it has reviewed each and every one of the letters that have been submitted. Mr. Trammell, from the state's perspective, before we do the change of plea and take the pleas, is there a plea agreement as far as recommendations that the state would like to elucidate for the record?
Your Honor, there is a plea agreement. May I remain seated?
You may.
Your Honor, there is a plea agreement that was reached between the state and the defense. I have it in front of me. I can go through it for the record.
I'd like to hear it.
Thank you. It said that the defendant agrees to plead guilty to 2 counts of battery. The parties agree that the defendant will enter an Alford plea at sentencing. At the time of sentencing, the parties will jointly recommend the following. A no contact order. That the parties agree that the no contact order remain in effect through the duration of the case. The parties agree to recommend that the charges run consecutive at sentencing. The parties agree to recommend the defendant completes a mental health evaluation and follow all recommendations from that evaluation. The defendant shall pay any and all restitution, fines, and court costs as deemed appropriate by the court. And any other conditions not expressly agreed to in the written plea agreement, each party is free to argue as they see fit. This is a non-binding agreement on the court. In addition, I had subsequent conversations with Mr. Smith. And in addition to what was originally sought out in the plea agreement, the defendant will agree not to appeal the sentencing of the court unless it's an illegal sentencing or they feel that it is in violation of the plea agreement from the state side. Is that
correct?
Understand on that part? And that is the essence of the plea agreement, Your Honor.
All right, Mr. Trammell, please repeat for me. I recognize that the plea agreement contemplates a plea pursuant to Alford. What was and I recognize that the charges are to be run consecutively. What was the portion in between that?
A mental health evaluation.
Okay, mental health evaluation, and what is the recommendation with regard to incarceration, probation?
Open recs, open to argument. On really the fines and the jail time is open to argument from both parties.
Mr. Smith, is that your understanding of the agreement?
Your Honor, that is.
All right. Was this agreement, was it presented to Judge Nass?
My understanding is that it was. I certainly feel like the court reviewed it before the remand, but maybe Mr. Trammell has some information.
Your Honor, I'm unsure if Judge Nass reviewed it or not. He was aware that, at least at the pretrial, that there could be an agreement coming in.
Okay. I understand that the state and the defense are willing to agree to an Alford plea. What if the court is not willing to agree to accept an Alford plea?
Well, Your Honor, then there is no plea deal, and the state believes that would kick the case back up to district court.
Okay.
Judge, I'm so sorry.
I was getting ready to ask you for commentary in conjunction with that. I'm not asked to accept an Alford plea.
Absolutely. Let me address that, Judge, because I think there's some valid reasons for it.
All right.
The court may not be aware that the family of Mr. Jared Goody have filed a civil suit. There is also a pending custody case. Quite honestly, Judge, I am not going to put my client in a position where they file those things simultaneously with a criminal case, and they're tracking simultaneously with her criminal justice rights and her constitutional rights, to where she may be put in a spot to say things that might be used against her when they have filed such litigation. Quite honestly, part of our presentation today will be that we believe that a large part of this case overall has to do more with those two driving forces than the actual allegations in this case. So I recognize, and I'm not an attorney if the judge knows my reputation, that does Alford pleas. Frankly, I think they're overused. I think they're misused. But I think we're at a point in this case where this is the very kind of set of circumstances where an Alford plea is appropriate. Because number one, we have some factual things that I can certainly go into if the court would have me do so before my argument. But we also have these simultaneous litigations that had nothing to do with my client filing and has everything to do with the victims filing those. And so I see no other way to proceed under these circumstances without this being an Alford plea, quite honestly. And so I think those are the opening comments I would make. If the court is inclined to have us make some factual arguments, I am prepared to do that as to why I think an Alford plea is very well on base with what has been agreed to between the parties and why the court should accept it. But I'll leave my comments with that opening.
All right. Ms. Goody, have you had adequate time to discuss what the nature of an Alford plea is with Mr. Smith?
Yes.
And have you had adequate time to discuss with him what effect or implication that may have on any civil case that is pending?
Yes, Your Honor.
And you understand, Ms. Goody, that the court could institute a punishment even though you are pleading guilty pursuant to Alford, that the court could institute a punishment that is within the court's discretion regardless of the fact that you would not be formally admitting guilt or at least admitting guilt pursuant to Alford. You understand that?
Yes, Your Honor.
All right. The court is going to be very candid. I was a little bit concerned when I saw this case come up on the court's docket that there might be Alford implications. I did not realize that that was part of the plea agreement. But I also understand that if there is civil litigation that is going forward, that there are bona fide reasons for an Alford plea. The court also takes note that we are here today pursuant to plea agreement that was agreed upon by both parties. The state has agreed to allow Ms. Goody to go forward in an Alford type scenario. All right. I will allow Ms. Goody to go forward with an Alford plea today. I feel like she has been advised with regard to what that means, and I will, at least from that component, I will go along with the plea agreement as reached between the state and the defendant.
Thank you, Your Honor.
All right. Ms. Goody, with that being said, you understand that there was an amended information that I referenced before that sets forth 2 counts.
Yes, Your Honor.
You've had the opportunity to review that.
Yes, Your Honor.
You've had the opportunity to review that with Mr. Smith.
Yes, Your Honor.
And you understand that if you enter a plea today by virtue of Alford, that you would be giving up your right to a trial by jury.
Yes, Your Honor.
And you realize that you would be giving up any of the defenses that you could have raised at that trial by jury.
Yes, Your Honor.
All right. Are you under the influence of any medication or any substance that would keep you from understanding what you're doing?
No, Your Honor.
Other than what has been reflected on the record by Mr. Trammell and accepted as the plea agreement, has anyone made any promises to induce you to plead guilty?
No, Your Honor.
And you understand that even though that is the plea agreement that has been reached, and that those are the joint recommendations that have been reached, you understand that the court maintains discretion to do what it wants to do within the confines of the law, which means I don't have to follow the plea agreement. You understand that?
Yes, Your Honor.
And if you don't like the result, or if it differs or deviates from the plea agreement, you understand you don't get to withdraw your guilty plea for that reason.
Yes, Your Honor.
Is anyone forcing you to enter a guilty plea against your will?
No, Your Honor.
All right, let's go through these counts one by one. And it looks like Mr. Smith has it present in front of you. Count 1 charges you with battery, cause bodily harm, Idaho Code Section 18-903, punishable up to 6 months in jail and or $1,000 fine, or both. And then the factual basis contained below indicates that Courtney, is it Uvon? Uvon Goody, on or about the first day of February and the first day of June 2020 in the county of Bannock, state of Idaho, did unlawfully and intentionally cause bodily harm to it, put poison with any food, drink, or medicine, and gave it to the person of Jaron Byron Goody. Did I read that correctly?
Judge, if I might, the only interesting part about this, and I want to work with the court so we make sure you feel comfortable because we appreciate you accepting the Alford plea. I recognize that the state had to file the amended charge and that is the amended charge. I think the way I am comfortable, if the court is okay, is suggesting that we recognize that under Alford, that if this went to trial, that there is a likelihood that the jury, after hearing the evidence, could convict of that factual basis. If that is the question that you're asking my client, then she is prepared to answer yes to that.
And Mr. Smith, I was going to go through that very inquiry with her, so I appreciate that clarification. I just asked, did I read it correctly?
You did.
All right.
And she's happy to let you know that.
All right. So, under Alford versus North Carolina, an Idaho Supreme Court case indicates that you can enter a plea, which indicates a acquiescence on your part, Ms. Goody, that you agree that you're not admitting the conduct specifically. However, you are conceding that if the case went to jury, a reasonable jury could find you guilty of that offense.
Yes, Your Honor.
So under that pretext and under that clarification, how do you plead?
Guilty.
All right. That guilty plea is accepted pursuant to Alford versus North Carolina. Let's find Let's move to count 2, battery, cause bodily harm, Idaho Code Section 18-903. Punishable up to 6 months in jail and/or $1,000 fine, or both. Courtney U. Von Goody, on or about the first day of February and the first day of June 2020 in the County of Bannock, State of Idaho, did unlawfully and intentionally cause bodily harm to it, put poison with any food, drink, or medicine, and give it to the person of Jared Byron Goody. Same question, same clarification with regard to before, recognizing that this is a plea pursuant to Alford. You are not specifically and expressly admitting the conduct. However, you are stating that if the state were to go forward with the trial in this matter, a reasonable jury could reasonably find you guilty of this offense. How do you plead?
Guilty.
The court finds that there was a plea entered. And Mr. Smith, are you supportive of these Alford pleas?
Yes, Your Honor.
All right. Court is going to find that Ms. Goody has entered Alford pleas as to count 1 and count 2, and finds that both of those guilty pleas have knowingly, intelligently, and voluntarily been given. All right, at this point, we will go forward with sentencing. I will start with the state. Mr. Trammell, you may go forward with any presentation you want, or you can start with victim's impact statement. Your call.
Your Honor, the state would give their recommendation first and then have the victim give
Very
their
well.
own statement.
You may proceed, Mr. Trammell.
Thank you, Your Honor. The state did not enter into this plea agreement lightly. It is not the purpose of this plea agreement to depreciate in any way the seriousness of the harm the defendant caused to the victim. One of the most difficult jobs of a prosecutor is to determine if a plea agreement is appropriate in any case, but specifically in a case that involves harm to a person. Many times in a case, additional information is brought to our attention after the initial charging of that case that could have an impact that was not originally anticipated for. The plea agreement was reached after careful analysis and consideration regarding the vulnerabilities of the case, potential impeachment and attacks of the evidence and witnesses, and other arguments the defendant could make to the jury. Knowing that the state has the burden to prove the charge beyond a reasonable doubt, and not wanting to risk a possible outright acquittal at trial, this plea agreement was reached. The state understands the frustration that plea agreements can have on people, and oftentimes nobody, including the state and defendant, are completely satisfied with any plea agreement. However, sometimes that is where the case lands. With that said, the state is convinced that based on the reports and gathered evidence that the defendant poisoned the victim. It was done with the purpose of causing harm to the victim, and it did cause serious harm to the victim and happened more than once. Based on the seriousness of her conduct and the intentional harm she caused to the victim and the community, the state recommends the following: that the court runs both counts of battery consecutive to each other, that the court impose the maximum amount of jail time for each count, that the court impose 4 years of supervised probation, that the court impose upfront jail time of 4 months forthwith, suspending the remaining jail time and giving any credit for time served, that the court continue the no contact order between the defendant and the victim for the duration of the case, that the court order the defendant to complete an appropriate mental health evaluation and follow all recommendations from that evaluation, that the court impose the maximum amount of fines, and that we're going to ask the court to leave restitution open for 60 days in this case. I have talked to the defense about it, and I don't feel that they're going to object to that. And again, the parties agree that the defendant will not appeal unless they feel it's an illegal sentence or in violation of the plea agreement. And that will be the recommendation of the state, Your Honor.
Mr. Trammell, a couple of clarification questions so the court understands the nature of the recommendations. One, with regard to the potential restitution, what are we looking at as far as potential restitution is concerned? I'm not asking for a dollar figure. I'm talking about what kind of restitution? Counseling services, medical bills?
Your Honor, from what I understand at the point, the victim had met with our victim witness coordinator yesterday to go over medical bills. I have not seen a number for that yet, but we are still gathering that information.
All right. And the state has made recommendation with regard to mental health counseling. Is there some sort of underlying diagnoses or some mental health issue that the court needs to be aware of? And I'm sure Mr. Smith may address that, but what's the state's position with regard to her mental health condition?
You know, I know in our discussions throughout the case with the victim in the case, I mean, they addressed concerns about the defendant having some mental health issues, and certainly with the nature of the case, we'd want to get that looked at.
Does the state have any concern with regard to the voluntariness of the guilty plea that was entered today?
No, Your Honor.
So that mental health issue doesn't raise to that level?
No.
All right. Mr. Trammell, any other comments?
No, Your Honor.
You had mentioned in chambers the potentiality of a victim's impact statement?
Yes, Your Honor.
All right, let's hear that now. Mr. Goody, let's have you come on over here where Mr. Herzog is. You can be seated, sir, when you're comfortable. You don't have to speak directly into that microphone.
Okay.
And identify yourself for the record, sir.
My name's Jared Brian Goody.
All right. You may proceed, sir.
Courtney and I were first married in December of 2010. We lived what I thought to be normal lives, and I would say we're decently happy. We did not spend much time together before we wed, approximately 6 months. I noticed a couple months into our marriage that Courtney lied very frequently. I noticed the small things in everyday life, details of the day. This person said this to me. Storytelling. It was often when she was telling a story about something. The bigger things took me longer to catch on to and made me realize that Courtney's life prior to me had forced her into mastering the art of deception. Cooper Goody, my son, was born July of 2012. I couldn't have been happier to be a dad. McKinley was born just a few years later in May of 2015. Courtney continued to lie to me the same way that she had all along, but we sort of just found our groove and kept on going through our everyday lives. I would get up, go to work, she would stay home and tend to the kids and the many other household duties that come with parenthood. And eventually, these issues we were ignoring as a couple kept rooting until ultimately we decided to divorce in 2018. This was a huge shock to our little family and not happy times at all. Our family was split up, and being without my kids for most of my time was very, very hard. I was willing to accept being lied to and accept the things that didn't work for me in our relationship in order to regain time with my kids. I was also very alone, and I missed Courtney. I loved her dearly as the mother of my children. I lost my spot.
Take your time, sir.
I wanted to do what was best for my family. We were remarried in 2019 and merged our lives back together as one happy family. Early on in our reunification, Courtney told me jokingly that she had plans of poisoning me when we had divorced. I took this for one of the many untruthful stories I had been told by Courtney, and the joking manner in which she told it did not make me take her very seriously. Courtney brought this back to my attention in a similar manner from time to time, in varying frequency from that point on. She even told me that her cousin Chance had told her just how to do it, and even how to dispose of a dead body out in the bone pit. I have heard the Murdochs, including Brenda, Dan, Steve, Tanner, Danielle, all of you guys reference the bone pile or the bone pit as a location on Murdoch Ranch where dead livestock are discarded. And that's apparently where my body could be hidden. While these stories did raise suspicion, Courtney had not often told the truth to me, and for that I gave less reason to believe her on this regard. Who was actually going to do something like that? We carried on what we knew as our normal lives, going to work, raising kids. My youngest child, Millie, was born in March of 2020 during the COVID pandemic. I began to feel very ill not long after. On June 10th of 2020, I went home from work feeling too sick to be there. We had already had people at my workplace with COVID, and I had very similar symptoms. I chalked my symptoms up as COVID and hunkered down to wait it out. Little did I know I would spend the next 8 months being tortured, manipulated, controlled, abused, literally having the life leached from my soul and body by the hand of Courtney. Every day was a battle for my life. I kept fighting. I tried my best to focus on the day when the symptoms would subside. I'm still waiting for that day. It has not come. Day after day, I experienced torturous symptoms, including brain fog, cognitive issues, hair loss, high fevers. My highest fever was 106.8, constant sweating and chills, migraines, eye pain, body aches, neck stiffness, nerve spasms, skin lesions, extreme heartburn, respiratory issues, digestive problems, excruciating stomach pain, bloody stools, nausea, vomiting, weight loss, chronic diarrhea, leg pain, fingernails and toenails yellow, brittle, problems sleeping, dizziness, crippling anxiety and depression. I felt such little hope. So many times had the thoughts of my children going through major life events without their dad played through my mind. I went to my family doctor, the ER countless times, the U of U ER, over and over again, only to discover nothing. I gained some hope when getting in front of the most prestigious infectious disease specialist in the country. If only I'd been fighting an infectious disease. The doctors did their best with many blood panels, COVID tests for less common things like valley fever, Legionnaire's disease, West Nile virus, Rocky Mountain spot fever, Epstein-Barr virus. I had CT scans, upper endoscopy, bronchoscopy, a spinal tap, brain MRI, you name it. I was going to attempt to list all the tests that I went through to figure out Courtney was poisoning me, but that turned out to be a long list totaling at 134 tests. None of these tests had the ability to detect the lethal levels of thallium and selenium Courtney was administering to me. I was on prescription high blood pressure medication, prescription thyroid medication, prescription anti-acid medication, Ambien to help with sleeping, antidepressants, muscle relaxers, nerve relaxers, anti-anxiety, highly addictive anti-anxiety pills, prescription medication for frequent urination, medication to help with excessive sweating, rescue inhaler for breathing problems. I had an evil, murderous mother escorting me to all of these doctor's appointments, taking notes, speaking for the vegetable I had become at this point. So many times I had told my children good night, thinking it would be the last. Courtney made several suspicious comments to my family members, pointing towards something dark. We thought maybe my medications were getting mixed up. The doctors confirmed that shouldn't be making me sick. Courtney came over to my parents' house to help prepare pies for Thanksgiving in 2020. During that visit, Courtney expressed to some of my family members her frustration in what her family had asked her to bring to their house in Hamer to help out with the Thanksgiving meal. Courtney's family asked her to bring napkins. Courtney said to my family members she wanted to make her own batch of stuffing and secretly switch it out with her sisters so that she could watch them all get sick. Courtney also told a group of my family members at our cabin that she gave me a little something to help me sleep one night. After reflecting on all of these strange comments over the years, I then decided to try not eating the meals she cooked for me. I felt slightly better. After some research, we found the Carlson Company and followed the instructed chain of command to provide a hair sample. The sample came back with tremendously high amounts of selenium and thallium. Learning this information took me by complete surprise. These values are too high to be environmental exposures. I should have been dead, but to Courtney's surprise, my will to live carried on. Looking back, I know that my life was spared to care and protect my children. I began chelation IV treatments the same day I received the results of my hair test. The doctors could not figure out why I was alive, but knew that we had to get that crap out of my system. What do I do now? We went to the Chubbuck Police Department. They didn't believe me. They told me I needed more proof. I continued to live in this nightmare. I noticed that as I would begin to feel better, Courtney would insist on getting me some kind of drink or food. As I got up one night to use the restroom, she sprung straight up from a dead sleep and asked me repeatedly, "Do you need a sandwich? Do you need a sandwich?" And then went straight back to sleep. I noticed that if I acted like my normal sick self after she would administer me some type of food or drink, I would be less on her radar. She would bring me in a drink or a plate of food. If I had the opportunity, I would flush it without her knowing. This was the surest way to hide my food so that she would think I had eaten it. Sometimes I would dump the plate of food in a cup or a mug so that I could dispose of it later. She would then come in and check on me, and I would fake the usual symptoms, and she would exit for a while. I began to regain some of my brain and strength. This crime was reported to Chubbuck PD on 2/16 of 21. Chubbuck PD decided to bring her in for questioning on 3/16 of 21. I want to thank the Chubbuck Police Department for putting an end to that month-long living torture. Courtney was brought in for questioning and told Detective Bystrom the same story she had told others. She poisoned me. I was given some questions by the court. I want to read the questions and how I responded to those now. Has this crime affected your lifestyle or those close to you? Yes. All of us had to move. Imagine trying to carry on with your life in the same place where all of this took place. Trying to cook a meal in the same kitchen she spiked my food and drinks in. Trying to sleep in the same room where she kept me at bay in, only to burst awake at night from a night terror and thinking I could see her standing at the foot of my bed. Courtney has caused me tremendous PTSD. I'm afraid to go out amongst people. I have a real fear of Courtney trying to finish the job. I have had panic attacks When I see something that reminds me of what she did to me, I feel my heart rate speed up, and it feels like my chest tightens up and I have difficulty breathing. Anytime food is involved, restaurants, barbecues, family events, it doesn't matter. I'm terrified to eat. It hurts to eat. Every time I see food in front of me, I'm reminded of Courtney's attempt on my life, and my guts feel like they twist into a knot. I can rarely eat without any digestive pain. I have lost close to 90 pounds since Courtney's arrest date. I cannot stress to you enough just how much this has changed me and those close to me. Have your feelings about yourself or your life changed since this crime? Why would she do this to me? Of course, my feelings about myself have changed. I was good to her. I always made sure she felt special and loved. How could someone I loved so much abuse me like this? Hurt and torture me, my family, my kids. What's wrong with me? Why did this happen? I struggle with my self-image. I'm quiet and less outgoing. Sometimes I feel like I would be better off dead. These kids are the only reason why the poison did not kill me, or my willpower to come out on top of this. Has your ability to relate to others changed? Yes, I have a very hard time trusting anyone. The betrayal and manipulation I have experienced by the hand of Courtney has permanently changed my ability to relate or even socialize. Has this crime affected your relationship with family members, friends, coworkers, or any other people? Absolutely. It has changed every single one of those relationships. Have you sought any type of victim services such as counseling? Yes, I see a counselor every week. Has this crime affected your ability to perform your work, make a living, run a household, go to school, or enjoy other activities you previously performed or enjoyed? If so, please explain how these activities have been affected by this crime. My brain does not function like it used to. Every area of my life is affected by this. I used to go out and ride dirt bikes, archery hunt, golf, many other things which are much, much more challenging for me to complete, if possible at all. My lungs are not the same. I get winded and have coughing fits. Dr. Martha Buitrago diagnosed me with silent acid reflux during the time Courtney was poisoning me. That means that the poisons Courtney was giving me were seeping out of my stomach as I slept and being inhaled into my lungs, wreaking what still feels like permanent damage. If you or your family members were injured, you may want to tell the court about the physical impact of this crime. You may wish to describe the physical injuries you or members of your family suffered. The physical injuries I suffered were listed above in my symptoms. After Courtney poisoned my mom, Shelley Goody, she thought she had a stroke. My mom thought she had a
Judge,
stroke.
I'm going to
Figured you
object
would.
here. First of all, we've been very patient to let him talk about a lot of things that I think run afoul of the statute, because I'm going to ask the court for a lot of latitude to address those issues. But at this point, we're going far afield from any evidence, from any charges, and from even any allegations that we've received from the state. When we start talking about other people and other so-called poisonings, I think I have no option but to object and say that's not sticking within the form where he was of following the court's recommendations of how this crime has impacted him, which is really what the statute allows him to do.
All right. Thank you, Mr. Smith. Any response, Mr. Trammell?
Your Honor, I would just add, I believe he is just commenting on how it impacted
him and his family. I understand the objection, but I think it's appropriate for him to talk about the impact, the potential impact it had on his family and how it affected him.
All right. Court is mindful that the victim's constitutional rights statute gives pretty wide discretion to allow the victim to speak as to how it impacted. The court is going to allow Mr. Goody, overrule the objection, and allow Mr. Goody to continue with his victim's impact statement. But Mr. Goody, I would just simply ask that your comments be geared towards how this has impacted you personally directly. Okay?
Thank you,
You
Your
may
Honor.
continue, sir.
Thank you, Your Honor. My mom collapsed on the ground and could not stand up. My mom has suffered a long list of symptoms just like mine. She's experienced extreme brain fog and cognitive issues, nerve damage, tingling all the way down to fingers and toes, body pain and joint pain. We've truly had to adapt to get by. The symptoms have not completely left. We have just learned how to manage. Amber, Hannah, Cole, and Lance all suffered symptoms at the hand of Courtney. Describe how long
Again,
these...
I'm going to object. He's talking about other people that haven't even been involved in our case. And I think it runs afoul of the statute because he's trying to tell you how those people have been affected, not himself.
I'm going to, Mr. Goody, I really do just want to focus on how this has impacted you and not others, because you're the sole victim in this case. All right?
Understood.
And I don't want to consider inappropriate information when I determine this sentence. So I'm going to sustain that objection, and let's just focus on impacting you directly, okay?
Understood.
Thank you, sir.
Describe how long these injuries lasted or how long they are expected to last. I would love to be able to answer this question. I would love to be able to tell Cooper I'll be at his graduation without feeling like I might be lying to him. Many of the suggestions and or prescriptions from my doctors are expected to be lifelong. Describe any medical treatment you have received or expect to receive in the future. I received a significant amount of medical treatment trying to figure out what happened to me before I knew that it was Courtney. After knowing what was causing my symptoms, I was first prescribed a medication by the name of Prussian Blue, which is available by prescription only and requires CDC approval to fill. It is used to treat thallium poisoning along with other toxic radioactive elements. My doctors also recommended chelation IV treatments. This is a process where chelators are injected in order to attach themselves to heavy metals in the body so that they can then form compounds and be excreted by the body. It is a horrendous process and takes a long time to see improvements. For the first several months, I was receiving 3 treatments per week in an effort to save my life. The effects of the treatment can best be described as a similar feeling to that when the substances entered my body. I've done hours upon hours of research and educating myself on how to detox the body, how to find more information so I can live a longer life. I recently found a new doctor that ran a blood panel that took 38 tubes of blood to fill. He found several other things wrong with me directly caused from the poison. My follow-up appointment is in July to find out the full report. Future treatments are unknown. You may also wish to discuss your feelings about the criminal justice system. I feel like the criminal justice system has looked us over. I feel like they were knowingly endangering the lives of my 3 kids, my life, my family's lives, the entire community's lives. Towards the end of May 2023, I spoke with Chubbuck Police Department detective who promised me they're still working on this. The problem so far had been that they couldn't get into her cell phone. They had the wrong password. I provided them the correct password. Why did it take them 2 years to do this? I had the password. I don't understand that. Why was that detective telling me they're working on things and we are here giving a murderer 2 misdemeanors? Your feelings and or opinions of an appropriate sentence. I do not feel like Courtney is safe to have in public. I will never rest easy knowing she is at large. This person is evil, knowingly dangerous, and has already tried to kill me, my whole family. I will never feel safe again because of what she has done to me. I have been told that I had 45 times the lethal amount in my system. My mom had over 100 times. What would the appropriate sentence be if she succeeded, if we were dead? What happens if I die a year or 2 from now? This woman is a danger to everyone that she's around. If you wish the judge to issue a no-contact order instructing the defendant to stay away, I absolutely wish a no-contact order be put in place that lists me and my children. I have heard Courtney talk about killing herself and my kids. I have provided Chubbuck PD with 2 journal entries of Courtney's where she talks about killing my kids. This woman is coming for me and my kids. Courtney poisoned me and admitted to poisoning me. Courtney spoke of poisoning herself and my kids. This person is sick, evil. You have proof that she wants to harm my kids. She needs to be taken off the streets. I expressed my concern for the safety of my kids to Steve and Brian. Brian individually on separate occasions. Brian's response to my concern for my kids' safety was that it was irrelevant. He explained that he cannot allow details of another case, being the custody case, to impede on his judgment on this case. You guys have her journals, her phone, her tablets, everything. You have details from the custody case. The details from the custody case are pictures of the journals that you have. Courtney has told me she wanted to kill herself and my kids. I gave Chubbuck PD 2 journal entries where she talks about killing them. If Courtney is out free, she will try to kill me and my kids. I would ask you, Judge Thompson, and this court, when will the appropriate time be to consider the safety of 3 innocent children? Please stop this madness. I am pleading with you to take a deeper look into this. This charge does not match her crime. She is manipulative. She is dangerous. She poisoned me and admitted to doing it. If you do not do something, Courtney will hurt me, my kids, and my family. Please do the right thing.
Mr. Goody, before you return to your seat, I just have an additional question. The Idaho Constitution has a victim's input provision, and then there's a statute reflecting it. And one of the provisions within the Idaho Constitution and that statutory provision is that you have the right to be consulted and give input with regard to plea agreements. You understand that there's been a plea agreement that has been reached with joint recommendations to the court that Courtney be placed on probation. Are you supportive of that?
Absolutely not.
Were you consulted about that?
Not in the manner that I felt appropriate. Brian called me in a couple weeks prior to, actually no, I in almost every instance have had to reach out for any sort of details. This time when I reached out, they asked if I wanted to meet. I said yes, immediately. And I came in the next day. They told me that there was talk of a plea agreement and that her attorney was going to submit a plea agreement, and once he had it in his hand, he would call me and read it to me. And I did not get a phone call where it was read to me. The nature of the plea agreement, he did tell me about. He did tell me that it was going to be 2 stacked misdemeanors, but I was just expecting the phone call that I was promised.
So you were at least at some degree given the opportunity to input.
Yeah.
All right. And you understand that the state doesn't represent you. The state has to make its own decisions based on its own discretion. You understand that?
I understand.
All right. Thank you, Mr. Goody. Any other witnesses or evidence in aggravation, Mr. Trammell?
No, Your Honor, if I may make a comment on
You may.
So I did meet with the victim and his parents. I believe it was in April, maybe late April. There was another attorney with me in my office to go over what the potential plea agreement could look like. During that meeting, I also explained why we were thinking about entering it, including going over what we consider to be strengths of the case and weaknesses of the case. And definitely before it was officially offered, they were aware of what the offer would be, what the terms would be, and this plea deal was conditioned exactly on those terms that I had discussed with them. And for the record, I want to make clear that the state absolutely does not think that the safety of children is irrelevant. And because it was addressed to the court, at least to the best of my memory, any discussions we had about the children revolving, putting them on the no contact order, we're explaining to them how when a case is filed, any motions and such basically is limited to the defendant and any listed victims in the case. That's my memory of it. But I just want to make clear to the court and everybody that we do believe that if there is ever any concern about the safety of the children, that they take legal action and anything necessary to do that.
All right. Thank you, Mr. Trammell. All right, Mr. Smith, turn your time over to you for mitigation.
Thank you, Your Honor. Well, Your Honor, other than the experience of being here in this case today, this courtroom holds fond memories for me. It was where I tried my first jury trial some 30 years ago. Back then, 30 years ago, I think the world was a different place. I've tried murder cases. I've been involved in every kind of case I can think of here in the little old state of Idaho. I frankly have never been involved in a case where I felt like the fear and manipulation was so thick. And I don't mean from the person sitting next to me. I mean from a family that has spent this last week in the press telling a story that looks nothing like the last 2 years of my life in this case. With 2 preliminary hearings, with experts, mostly on our side of the case, with medical doctors, with testimony from the man you just heard from twice on the stand, with a Brady disclosure about his testifying not being honest and truthful, which we already knew because when he testified at the first prelim and lied under oath, his own doctor took the stand and indicated that he had lied under oath. I've got them marked, and we'll probably read them to you before we're done today. Then we come to the courthouse today with fine people that I've known for most of my life. People from Hamer, Idaho, who ranch and who are the salt of the earth. I've known them my whole life. I've known a lot of the Murdoch family my whole life. I've played ball with them. We've raised our kids together. I know this family. And there is not one thing I've heard today that reflects them or my client. So let's talk about the facts of this case now, because that's what I'm going to focus on. I'm going to focus on the record. Does this court really think that the two men sitting across from me that I know well and respect well would allow a murderous woman to get away with the kind of conduct that you just heard about from Mr. Jared Goody? The answer is absolutely not. Because I think if they were to tell you what's in their hearts, they would say, what you just heard isn't reflective of the case they had. It's a curious thing to me that when I started, we used to call people who were victims as witnesses. They used to have to undergo a little cross-examination after raising their hand and taking an oath to be truthful. But I'm going to be just very blunt about this. I don't think that would have mattered today. Because of the Brady disclosure and because of my two first preliminary hearings where Mr. Goody himself lied about very critical information to where a Brady disclosure had to occur, I don't think it would have mattered if you had him raise his hand to the square today. And 90% of what I just heard never came out in two contested preliminary hearings where he himself testified. I find that very curious as well. So let's talk about the facts of this case. You know, we have a case going on in Utah right now where a mother killed her husband via poisoning, and then she wrote a book for her children. Now, she hasn't been convicted yet, but it's not looking good for her, and if that happened, it's horrible. But you know what the substance was? It was fentanyl. That's an easy poison case. Somebody has fentanyl in their system, and you go get a lab test, you all of a sudden have to say, hey, that's a controlled substance. Where'd the fentanyl come from? Pretty easy to figure out. Pretty easy to do. Here's the problem in this case. This case is supposedly a selenium poisoning case. Do you know that if you brought in a toxicologist and every person in this courtroom was tested, we all have selenium in our body. Why? We need it to survive. Without selenium, we die. So every one of us is going to have selenium in our body. We're walking around with it right now. It gives us thyroid help. It allows us to digest food. It's part of a chemical that comes from the earth and is grown in every plant that we grow. We eat it every day. It's in our water. One of our experts, Dr. Hill, just got done with federal litigation. He's probably the foremost expert. We had him in our case on selenium. You know who he is? He's a veterinarian. You know why veterinarians know so much about selenium when medical doctors don't? In fact, the two medical doctors that testified in this case, neither one of them knew anything about selenium or what the situation is when you get too much of it. Dr. West, in his comments about selenium, I'll quote from the preliminary hearing, page 52. My question. All right. So based on that level of selenium that is mentioned in this report, the report that was mentioned that came from the Carlson lab, which we'll get to. It's a report that we had that said that Mr. Goody's selenium levels were high. This was the first preliminary hearing that Judge Clark sat on. So I'm asking his medical doctor, who, by the way, never said that he was poisoned. He thought that he had COVID, and I'm not so sure that he didn't hedge and say, I still think that's what he was dealing with. So I'm bearing down on this selenium issue on poisoning. And I say, so based on that level of selenium that is mentioned in this report, what effect, if any, to your knowledge, would that have on the human body? So and this is his answer. So when I got this from the lab, I looked. I tried to find whatever I could about what selenium is going to do. And there's just not data out there. So to say that what selenium does, what a high selenium dose, or what that level does, I really don't know the answer to that. That is the sum of the medical testimony in this case, period. That statement right there, from a medical doctor, from that man's medical doctor. So I heard about other doctors today, poison, stuff like that. They were never disclosed to me. They didn't come and testify. Nobody even said the word poison that was a medical doctor. You know why? Because here's how this case unfolded, Judge. The Carlson lab, which this family used, not law enforcement, prosecutor's office didn't send off to Carlson. Law enforcement didn't send off to Carlson. You know who did? The Goody family. The Goody family claims that they took a hair sample. They claim that it was sent to Carlson. They claim Carlson did a toxicology report. And they claim that the report that we're now left with from Carlson that came back shows elevated selenium. That toxicology report doesn't say he was poisoned with selenium. It simply gives a readout of what his levels were. It gives copper. It gives a lot of other things so that we can take a look. You know what else it gives? A THC level. This is where the Brady disclosure comes in. It showed a high level of THC in Jared Goody's body. So, at the preliminary hearing, because there is a tight tie between selenium and weed. Why? I just explained it. Everything that grows out of the ground has selenium in it. Marijuana, specifically, you can Google it now. You can look at all kinds of medical journals. I've spent 2 years doing it. So have my experts. Anytime somebody's growing marijuana, if it's not in a lab, it's going to have high levels of selenium in it. Because marijuana is one of those weeds that takes all of the metals out of the ground. If you compare marijuana to any other weed, the metals in marijuana are sky high. For some reason, it needs and likes those nutrients. Selenium is heavily in marijuana. My client knew that her husband was a daily marijuana user. And that wasn't the only drug he was on at this time. In fact, he'd been placed on felony probation at this point in time for insurance fraud. And to not get caught, he was also using hydrocodones, smoking it on the weekend because it would be out of his system by Monday. Now, why is that relevant? Here's why, and it comes right back to the record. My client was going to these doctor's appointments because in her mind, part of his problem was the drug problem. And I dare bet that there's nobody here supporting him today that doesn't know about his drug problem. But he wasn't being honest with his doctors about the drug use. He's sick, and he's got something going on, but he's not telling them that he's using drugs, and he's on felony probation. And that's one of the reasons he's not being honest with his doctors. So I asked Mr. Goody about his marijuana use because there's a direct tie into selenium levels, which both came back high on the Carlson case, on that lab report. Here's what he says. Well, do you use marijuana? My question to him. No. Were you using marijuana at the time? No. If this drug test shows, the Carlson test, which I'm holding up at this point, shows positive for THC, you're saying this isn't an accurate test. His answer, I don't remember seeing that. Question, okay, well, let me ask you this. Are you aware that marijuana contains high amounts of selenium? Answer, no. Question, have you ever reported to your doctor that you use marijuana? Answer, no. Has your doctor ever asked you if you use marijuana? No. Well, that's interesting because when Dr. West takes the stand, guess what Dr. West says? Right on page 52. I had a conversation with Jared about the high levels of THC from the report. They had a conversation about that. So he lies under oath, not once, not twice, but about 8 times about the lack of use of marijuana. But then it's interesting because the state's next witness is his own doctor who testifies that they had a conversation about that and about the lab report. Right there. So what happens? This first preliminary hearing, the judge dismisses the case. Back to a comment that Mr. Goody made just a moment ago, he's hopeful that you'll really dig in, because nobody has yet. Nobody has dug into this case for 2 years. There hasn't been selenium experts. There hasn't been his own medical doctors. Nobody, I guess, in his mind has testified under oath in a court of law. Not only did that happen the first time, it happened the second time. Why? Because after we got the dismissal the first time, which I think was absolutely appropriate, here we go again. And here comes the charge again. And I think the reason that the charges come is because you have a family who knows they're in a custody battle. So let me talk for just a minute now about these so-called confessions of my client. Because as you know, Judge, in a Brady disclosure, Brady not only says that disclosures might be important for evidence that's before the court for guilt or innocence, but also for punishment. You today hold the stick of punishment, and Brady violations gives you the opportunity to hear about those Brady violations and make things appropriate. I not only had one Brady disclosure in this case, here comes another one. After this family goes to the Carlson lab without any chain of custody, without any law enforcement being involved, and frankly, after getting a lab result that doesn't even have an affidavit signed by the toxicologist who supposedly conducted the test, never have we seen that. The state still doesn't have it. They tried to get it. We continued the prelim numerous times while we waited for a real toxicologist that supposedly did the labs to come to court or send us an affidavit. It never came. Still today, before sentencing, there is no signed off document from a toxicologist that that report is true and correct. Now that's curious, isn't it? Because you know why? If you Google the Carlson lab, the first 15 things you'll come up to is all of the problems they've had and the cases they've lost. I don't think they've had one case that's made it past a federal court judge under the Dober standard. That's how bad this lab is. They've been questioned on their tactics. They've been questioned on their scientific reliability. They've been questioned on everything. And what makes it more curious to me is they're working directly with a family who's in a custody battle who says, guess what? We think she's a murderous poisoner, and here it is. Well, that lab helped the same family in the Brittany Murphy poisoning case, the actress. They sent a lab and said, guess what? Selenium levels are high. A few other things are high. We think she was poisoned. That litigation went through and they were completely destroyed. This is the lab we're dealing with. We're not dealing with the Idaho lab. We're not dealing with a lab where law enforcement was involved. We're dealing with a lab that the family went out and found and mailed off some stuff according to what they said, and we received something back with no affidavit from a toxicologist even giving any credibility to the report. That report was allowed into 2 preliminary hearings because the rule allows for that kind of structure to have something come in at an early stage that the court can rely on for purposes of probable cause. But there is nobody, in my opinion, that if we would have gone to jury trial could have testified until the state could produce a toxicologist from that lab. And If I were the prosecution and somebody was telling me that I wasn't doing my job and hadn't dug in, because I've watched these men work this case, I'd stand up and say, guess what? The lab that they went and found, the lab that they used, the lab that they circumvented law enforcement and went to, never sent us anything that shows credibility on these lab reports. That's where we currently stand today. Brady disclosure number 2 in this case. The detective that then, or officer, who then helps go and supposedly get a confession after the family has already done their work, gets fired for what? Lying. I love that Jared starts today by saying this is all a liar right here standing by me. I'm only aware of a few people who've lied in this case under oath. We've got him, who's lied under oath, and we have the investigative officer that loses his job with the entity at the Chubbuck Police Department, who he's employed with, for lying. And then here comes the second Brady disclosure to the defense. I have not, in 30 years of practice, had 2 Brady disclosures in the same case ever. And I've got them in this case. So let's talk about why the family used the Carlson lab, now that I've laid that out for you. This family came to some conclusion on their own, I think it was for purposes of custody, that what they had to do is paint a picture that Courtney had mental health issues and that she was poisoning Jared. Note, they never take any food. You just heard him say that for months they thought this was going on. They never take a brownie, they never take a sandwich, they never take a smoothie, they never take anything and say we're going to go have it tested. Would have been easy, but that doesn't happen. What they do is they use Carlson, and that's the only lab we have with no toxicologist. But before this happened, she'd had their youngest daughter, Millie. She probably was suffering from some postpartum depression. She's at home, she's cleaning the house. Jared's mostly playing video games. And the reality of it is that he comes to her one day and says, hey, my parents think that you're the reason for my sickness. In fact, they think that you might be poisoning me. So here's what we got to do to get them off our back. I'm on your side. But to get them off our back, you need to go to BHC for the weekend. If you'll go to BHC for the weekend and get this figured out, what you're dealing with since this pregnancy and delivery of our youngest child, it'll get my parents off your back. That's what'll happen. So it takes days for him to convince Courtney to do that because she's still breastfeeding the baby, an infant. She recognizes that in her first pregnancy, she had some postpartum depression. And so eventually her husband convinces her, hey, maybe I'll do this. And especially if your parents think something crazy, like I'm trying to hurt you, then I'll go to BHC so we can put this madness behind us. So they go to BHC. The forms that they do on the intake are quite interesting. We got them. We subpoenaed them. It's interesting how they say on the intake to Courtney, why are you here? Well, I don't know. My family thinks maybe I need some mental health treatment. Jared jumps in. She's suicidal. Courtney looks at him and says, what? I'm suicidal? Yeah, she's suicidal. You're suicidal, ma'am? Now we're in a whole new ballgame. Now we've got somebody who's reporting that she's suicidal. That was never what she went there to report. But he reported it. Question number 2. Have you ever tried to hurt yourself or kill yourself? Absolutely not. And I have a new baby at home. Guess what Jared does? He pipes up. He gives the answer. What's the answer? He gives the answer of, she's tried to take her own life. Well, now we're at BHC, and now we're in a whole new ballgame, right, Judge? We now have her husband saying she's suicidal. They're not going to let Courtney leave there. They think that they've got somebody who's suicidal, and she's denying it, but her husband's got it figured out, and we got to help this guy because she's suicidal. So they take her into custody. And for 6 days, They talk to her, and I think they start to figure out, guess what? You're not suicidal, and you've never tried to kill yourself, have you? Record's pretty clear about that. But they put her on some drugs. They put her on clonazepam, some other narcotics, and some things that are pretty hefty, and they let her go home. Well, in the meantime, the Goody family, being the grandparents that they are, they've got the older kids at their house. It's going to be hard to have a custody battle here, but they've got the older kids. She eventually gets the baby back, and here comes Brian Goody, the father, over to the house. Courtney, we've had a great relationship. I love you, you love me. I need you to tell me the truth. If you'll just come clean about poisoning my son, I will make everything right. We won't battle for the kids. We'll get you your own place.
Sir,
Come on. Let's go. Out.
You know that's bullshit.
Sir, stop.
You know it too, Courtney.
Let's go. Let's go. Out.
Tell me when you're ready, Judge.
just a moment.
Thank you.
What are you guys going to do?
Just a moment.
Judge, I'd indicate that my family and my client put up with that coming into the courthouse today. So I'm not surprised. So let me finish. So he has 3 meetings with her where they open with prayer. He gives her a priesthood blessing in their religion. And all of this is manipulating her to confess that she has poisoned their son. He does all of that without letting law enforcement know he's doing it. So law enforcement isn't even doing the investigation at this point in time. It's Mr. Goody and the Goody family, and it's all with what I know in their minds happens to be what will ultimately be a custody battle in this case. So it's on about the 5th or 6th meeting where he's got Courtney convinced that if she will just finally say that she poisoned their son, that they will leave her alone and she'll get to have the kids back in her home. And she's still dealing with a new infant, probably some postpartum depression, on medications from behavioral health, which they finessed to get her into and get her going on that. And now we're using some religious manipulation, and then he pulls out the recorder without her knowing. And he records the only bit of evidence that the state has been able to give us of an admission which came to Brian Goody after the kind of manipulation that I just explained. And even then, it was a half-hearted admission. But here's the interesting thing about the admission. After the admission came, there was no real way that they knew how the poisoning had happened. They had to figure out, well, how did she get that much selenium in somebody's system? Judge, you can't go buy selenium supplements and get selenium levels high in the body unless you take like 10,000 bottles. The detective learned this, so he realized after checking at Walmart, can't buy it at Walmart. Can you get it on Amazon? No, can't get anything on Amazon that's that high. Okay? So here's where they go with their conclusion. Well, Courtney's parents have a ranch. And in a supplement that we give cattle, it's high in selenium. It's also very high in copper. In fact, 10 times the amount of copper in the same bottle. So if your selenium level's going to be high by taking that, your copper levels are going to be off the chart. The interesting thing about the Carlson lab test is the copper levels were normal in Mr. Goody. Had he been given any of those cattle supplements, the copper would have been astronomically higher than the selenium. So our expert, Dr. Hill, says, got news for you. That's not where the source came, but that's not the only reason that's not why the source couldn't have come from that. That supplement for cattle has to be injected. They can't give it to any cattle orally, because the second a drip drop of a head of a pin, this was explained by the expert and would have been to a jury, if you dip one pin into that and put it on the tongue of a cattle, it'll barf probably for hours because it tastes so horrific. Same with humans. If you were to take a single pin drop of that supplement and mix it in a whole plate of beans, one little pinhead in a whole plate of beans, if somebody were to take one bite of that bean, they would throw up. They could not ingest it. If somebody was poisoned by selenium from the Murdoch's ranch, it had to be injected. It's the only way that could have been done. This is the case that is so strong that they want you to look into. So, our experts are prepared to come and testify about that. The only expert that was ever brought in by the state was a man who I respect from ISU, who's a toxicologist who had nothing to do with taking this test. And this court may recall that in the preliminary hearing, I asked him, how many poison cases have you been involved in? 0. How many selenium cases have you been involved in? 0. That is an expert that would never make it past Dober in the federal court, and frankly, I don't think that he would have made it past Judge Nass in state court to be qualified as an expert. Dr. Hill, on the other hand, who's our expert, he's done a ton of selenium poison cases with cattle. The last one he did, and I'm going to end, I'm getting close, Judge, but I felt like you needed to hear this with the latitude that I gave with that last statement. In a federal court case that just finished for declaratory injunctive relief in the United States District Court for the state of Idaho, Center for Biological Diversity, Western Watershed Project, and Wild Earth Guardians were the plaintiffs, versus United States Bureau of Land Management, Mary D. Aversa, the defendants. We have a scenario where, unfortunately, the Caldwell Canyon mine, which is on the Blackfoot River, allowed a bunch of selenium and other minerals to get into the water from the mining process. And thousands of cattle died up and down the Blackfoot River from the selenium levels being too high from the water. In fact, I think had Mr. Goody had their water tested, that's probably where he was getting high levels of selenium, because that's usually where people get high levels of selenium, with one other thing, and that's marijuana. If you're not buying marijuana from a place in a state where it's legal, where they grow it, where they measure those, that's one of the reasons why people argue that, hey, guess what? Vegas and these places that have legalized marijuana, it's safer. When you're buying it from a guy out in American Falls who grew it on a ditch bank, you're probably getting high levels of selenium and other poisons from the ground that can kill you. So we're talking about two areas where selenium poisoning usually can come from. Part of it is marijuana, of a daily marijuana user, and from water. In this case, it was determined that they not only poisoned the water with selenium, but all the particles from the mine were doing the same thing. Frankly, there's a good part of this that says that probably a lot of this reached the water source in Pocatello. I wouldn't be surprised if people sitting in this very room probably have adverse effects for that. That's a 21 case where declaratory judgment was entered, and my expert, Courtney's expert, Dr. Hill, was the primary expert in that because he's the foremost expert on selenium poisoning because it usually happens in cattle. He also is the foremost expert on the supplements given to cattle, and there is no way that Courtney Goody poisoned him with selenium. So, I understand that here you sit on a case, an Alford plea. But what's it for? It's for 2 batteries. And how does it get that way? It doesn't get that way because Mr. Herzog and Mr. Tremmel spend 10 minutes looking at a case and explain to the Goody family that, guess what? We don't care about kids and we don't care about you, and this is what we're going to do. This comes from a 2-year hard-fought battle with experts, with 2 contested preliminary hearings, and we are at a point where, frankly, had we gone to jury trial, I think my client would have been acquitted. But it's a big risk, right? This court's done cases like this. My client has an offer come for misdemeanor batteries. She hasn't seen her kids for 2 years. This family got an order and her baby was taken from her. She was breastfeeding at the time. She has not seen her children in 2 years because of this case, because of the case that I just laid out for you, the one that the Goodies want people really to look into. I hope the press looks into it, because the press has done a great job this week at putting a story out there from the Goody family, but it's not based on the record, and that's unfortunate. But if you look at the record, if you look at this case, that's why we're here in your court, and now I'm seeking justice. I'm seeking justice for my client. So what are my recommendations? My client did 9 days in jail. She did 120 days on an ankle monitor of house arrest. She's been on a pretrial release for over 2 years. She's done nothing wrong. She obeyed the no contact order with her own 3 children. She hasn't even been able to see them. How many people do you know violate no contact orders all the time, especially when they feel like they're being treated unjustly? My client's done everything right because she knew that at the end of the day, this manipulation of this family would come to a head. And I think it's coming to a head. The next step will be in the court where the children are. Do you know the first time I think that any of us ever heard that the children had been threatened by my client was today? I've had that man on the stand twice, and he never took the opportunity under oath to tell the court that my client threatened her own children. That's ludicrous. She has never threatened her own children. She's never done anything to the Goody family, and yet here she is stepping up, taking some responsibility so she can get to the next level and try to see her children after 2 years. So I understand you have a tough job here today, Judge. It's a tough job. But I also looked back at the simple battery cases that I've done over the last 10 years, many of them down here in this county. I couldn't find a one. Even the worst one that I did, somebody got 30 days in jail. The state's asking you today to impose 4 months of jail time after my client has done 9 days in jail and been on a monitoring device for 120 days on house arrest. What's she done after that? She's out working 3 jobs. She's employed at 3 different jobs every week, working her butt off to survive and pay her legal bills and get back to her kids. And she's facing manipulation. She's facing an unfair press story. She's facing the innuendo that was stated in a victim impact statement today. She's facing all of that. And now I'm going to say the same thing that Jared Goody said to you. We are hoping that you will see this for what it is. We think you will. I think this court's well aware that cases like this aren't taken lightly. The last point I would make is this. There's one other thing that Mr. Goody didn't tell you when you asked a question directly about input on the plea agreement. This case went to a mediation with Judge Dunn. Parties spent a half a day mediating this case. Any implication at all that those men right there didn't spend time with that family right there in this case is a lie. We had a mediation that didn't lead to the deal that day, but it ultimately led to the deal where we are today. So, don't let anybody tell you that this hasn't been fair for the Goody family. And I hope the press will do a better job at digging into the truthfulness of these so-called allegations. Because when you go to the record, when you take the testimony of the medical doctors, when you take the testimony of the experts, when you want to talk to the experts about what's really going on here, this isn't a fentanyl poisoning case. This isn't a poisoning case at all. This is a case that's been manipulated by a family who have now filed a civil suit and who have also filed a custody suit. And both of those will be hotly contested, I will guarantee you that. So, we lay it at your feet with a woman who has no prior criminal history, with someone who was suffering from postpartum and had her child yanked away from her. She's been 2 years without seeing them. She did 9 days in jail. She did 120 days on an ankle monitor. And she has now pled via Alford to 2 simple batteries. I hardly believe that any more jail time will do anything to justify this case. Now, if we're worried about the Goody family heading back out to the press and saying, oh, Judge Thompson let a murderer off. That's what they're calling her, a murder. First of all, nobody died. I don't even know where that comes from. Second of all, even if you wanted to believe that, people have to understand that unless they're here, unless they heard the evidence in the first 2 preliminary hearings, unless they've read the court record, unless they know the information that you now know, unless they lived a case for 2 years with sleepless nights to figure out a way to get justice for their client, then I hope they're going to be responsible in how they tell the story of this case. But I don't believe that's the day and age that we live in. It's more about thumbnails and what'll get readership and what'll drive people to a website and how many things can they get so that they can keep advertising. But what I appreciate, and this is my closing point, about where I stand today in this courtroom where I started my career is that beautiful sill above your head and the beautiful opportunity that we have an independent and detached magistrate that can look at this case and do justice. The unfortunate thing is sometimes people out in the community don't know the real story, and they might even take a pot shot at a judge for a sentencing. It's usually from people who've never been down here, never seen how the system works, never involved in trying to do anything positive in the justice system. But I'll tell you what, they're always the first one throwing stones on Southeast Idaho News' comments. But grateful for me, I have confidence in you, I have confidence in that seal, and I have confidence in the rule of law in this country, which I think under the current circumstances will ultimately save this country. And with that, I submit it to you, Your Honor.
Thank you, Mr. Smith. Mr. Smith, I have a few questions.
You bet.
And I'm actually going to take these in somewhat of reverse order in the way, chronology from what you argued. You had made mention that there was a no contact order and your client had been separated from her children for a period of time. I went and I looked at the record in this case as it existed before the district court, and obviously since it's been remanded. Has there ever been an effort to modify that no contact order?
There has, Judge. 3 times we were in front of Judge Jarman, specifically because she has control of the case there. And until we had something from her, it didn't make a lot of sense for us to come back into the criminal case and try to modify.
Okay, so to clarify, there is a civil protection order and a no contact order.
There is. And so we have been waiting, and I think, frankly, that court has been waiting for a determination in the criminal case. So we've had a right hand and a left hand, and until we could get both hands moving in the same direction, it didn't make sense for us to go back and try to amend the no contact order. Frankly, Judge, I would love the no contact order amended at this level to have a no contact order put in place as to Jared Goody, but not the children. All that does then is give Judge Jarman, who's going to have jurisdiction and will have jurisdiction over the pending civil matter of custody, it would give her the authority to determine if that changes. So even if this court modified that order, not addressing it to the children, which I don't think from a criminal standpoint there's any allegation or any proof that it shouldn't be modified as to the children, but just so you would know, there was still a check and balance in place that Judge Jarman would have in front of her.
Did Dr. Hill testify in the preliminary hearing that was pending before Judge Clark?
Judge, he did not testify in that
Okay,
preliminary.
what evidence do I have with regard to Dr. Hill's testimony?
You know, Judge, and I think you know by my comments, if I didn't make it clear, I tried to make clear that his testimony would have only been heard in a jury trial. He did not testify at the preliminary hearing.
At either preliminary hearing, because I know that he did not testify in the preliminary
Correct.
hearing that was
Correct.
conducted in my
And-
court.
And I guess you treat that as an offer of proof from a standpoint of what our expert over the 2 years has been prepared and would have been prepared to testify to. But again, I tried to make it clear that we really haven't had expert testimony or medical testimony from anyone who's been able to clarify this as a poisoning case, and especially a selenium poisoning case. That's the weird thing about why we stand here today in front of you.
All right. Dovetailing into that question, there was some argument made with regard to the usage of THC and blood levels of selenium. Is there anything in the record, any medical testimony in the record that supports that contention?
Yeah. Judge, great question. I asked the 2 medical experts that the state called at the preliminary hearing about that, and both of them indicated that they were unaware and had not researched that issue and had no opinion to render about that. So certainly in the record, there is nothing there other than the fact that we have high levels of THC in the document that came from Carlson, and we have a high selenium amount that came from Carlson.
And also dovetailing with regard to that issue, there was an argument that was made in conjunction with the purchasing of THC and being attributable to some particular ranch that selenium levels was fine. Is there any evidence in the record of that?
Let me just clarify your question. You mentioned the ranch where the selenium was and then marijuana, and those are 2 separate issues. So did I miss the question?
Well, I think that is actually where I'm going with the question is there any evidence in the record that supports any either causation or correlation between those 2 items?
Yeah, not the marijuana and the allegation of where the selenium came from. Although I will be honest with you in saying, and the state can certainly weigh in, I don't believe that there was ever any testimony at either preliminary hearing that the selenium poisoning came from my client's ranch. I just think that's been innuendo that the family has stated, and they filed a civil suit against the ranch claiming that's where the selenium came from.
Mr. Smith, let me narrow my question a little
Okay.
bit because I think we've missed,
Okay.
we've crossed streams. In your argument, you indicated that Mr. Goody could have potentially been purchasing THC, let's just say marijuana for the purposes of argument today.
Right.
And let's presume for the sake of the record that he was purchasing and using THC during the relevant period of time. Is there any evidence in front of this court, either by virtue of testimony at the preliminary hearing, any medical documentation that would support that, 1, the THC or marijuana that he was purchasing contained selenium, or 2, that who he was purchasing the marijuana from?
I'm with you now. Let me answer that. At the second preliminary hearing, after we'd been given the disclosure that Mr. Goody had lied in the first, which we already knew, but the state did their job and Brady disclosed, you may recall that and I don't have the transcript to the second preliminary hearing, but my notes reflect that when Mr. Goody was on the stand, I asked him about the marijuana. I asked him where he buys his marijuana, and what he did initially is admit that he used marijuana, but then he took the Fifth Amendment on the other questions that I asked.
And I went back and listened to the preliminary hearing in preparation for today. The question was asked, Mr. Trammell, indicating I do not represent Mr. Goody, but I think that there needs to be at least an instruction as to, with regard to his invocation of his Fifth Amendment rights, by which I did. He never answered the question.
Correct. So that's really what we're left with, I think, with your specific question.
Very good. Last question, Mr. Smith, with regard to your argument. Actually, I have two questions. One, with regard to the Brady disclosures that were raised, was there any motion filed before the district court to sanction the state for not complying with Brady?
Judge, great question, and there was not, and here's why. Because I felt very good about the fact that when the state learned of the Brady problems, which weren't theirs, wasn't in Mr. Herzog's office, it was with a police officer who'd been dismissed for lying, and it was with a hearing that we all attended and saw the perjury that occurred, and both those disclosures were made to me, and I was comfortable with that. Now, had this case not been ultimately amended and a plea agreement reached, those motions absolutely would have been filed in the district court. But they would not have been aimed at the prosecution, because I think the prosecution did the right thing in disclosing. I certainly would have been talking about the possibility of limiting some evidence by way of the detective and some other issues that would have been involved with that.
Okay. And the Brady disclosure that was raised at the preliminary hearing that was pending before my court dealt with the officer and his termination in conjunction with some sort of lying or fibbing or something to that effect, but there wasn't any evidence that that officer lied in conjunction with this case.
There was not, Judge, with one small exception, and I'm going to be very candid in saying I don't remember if this came up in either of the two preliminary hearings, but in the affidavit of probable cause, the officer had to take the recordings and do some things, and I think he used the word in the affidavit, manipulate, to get some of the recording to be able to be heard. And part of our contention was that that potential manipulation was not an accurate reading of what the recording was. So had there been ongoing litigation with Judge Nassen in front of a jury, we would have been arguing that we had a sense that the officer was not being honest in how the recordings were handled and dealt with, or the interview. So you're right, though.
It's impeachment, but it wasn't directly correlated to this particular case.
Absolutely.
The final question that I have with regard to the argument that has been made today is with regard to the allegations with Carlson Labs. And I recognize that you cross-examined with regard to Carlson Labs pretty extensively in the preliminary hearing. As I indicated, I went back and I listened to it. And so I take note that you questioned the credibility of that particular lab. But is there anything in the record other than me Googling it that would indicate that they are anything less than a credible lab other than your argument?
Great question, Judge, and I would say no, but I would give you this caveat. Mr. Herzog was very professional in calling me one day and indicating that, and he can correct me if I'm wrong, that they had put in upwards of 15 calls to this lab to connect with somebody in preparation for the preliminary hearing to either have somebody testify, even if it was via Zoom, which we agreed to. I said if they can do it via Zoom, we would allow that, or get an affidavit. Ultimately, an affidavit was sent, but the affidavit was from an office person who indicated that they were the vice president of the company, but acknowledged that they had had nothing to do with the actual testing of the lab. And I believe that that affidavit was submitted at the preliminary hearing and would be part of the record, at least in the first one, if not in the second one. So my argument for that would be this. I don't have anything else on the record about them other than how they conducted themselves with the particular test that this family is asking you to rely on to find it accurate. And that is that the lab was given so many opportunities to send what we needed by way of an affidavit or communicate via Zoom in one of the preliminary hearings and would never do it.
It's the last question, Mr. Smith. Thank you.
Thank you.
Ms. Goody, you have the opportunity to make a statement to the court if you so desire.
Judge, she would love nothing more, but I have advised her with the other two pending litigations that she's probably not going to do that, and we hope that you would understand why.
I do. Ms. Goody, I still have to have the acquiescence from you. Is it your intention not to make a statement today?
Yes, Your Honor.
All right. All right. Mr. Trammell and Mr. Herzog, the court had several questions. Mr. Smith made considerable argument in conjunction with this. I will give you a brief opportunity to respond if you need it.
Your Honor, the state would just state that we know the court is familiar with the case. The state stated their position based on the reports and the gathered evidence. We do believe that the defendant was innocent.
All right. All right. Well, this very interesting case, and obviously emotions are running very high in this matter, and understandably so. I start out every one of my sentencings that I do downstairs in my regular courtroom with explaining to the defendant that I have to consider four specific factors when determining an appropriate sentence. One, how do I protect society as a whole? Two, how do I deter you and how do I deter others from similar conduct? Three, whether there is any restitution owed to a victim, which is just a fancy way of saying, did your actions cause consequences that are monetary in nature, and is a victim owed any compensation for those actions? And the final thing that the court has to consider is rehabilitation. And that means, is there any treatment that the court can afford to you to make certain that we do not see you as a repeat offender in our court system? And it has been contemplated in this plea agreement that you undergo some sort of mental health evaluation and complete that treatment. So that is what is contemplated by the plea agreement that has been presented to the court. The court anticipated to some degree that there would be an Alford plea today. It didn't come out the way that I necessarily anticipated, that it may be an issue. The court was not aware that the parties had reached a plea agreement that allowed Ms. Goody to enter an Alford plea. I don't think we can lose sight as to what an Alford plea means. An Alford plea means that Ms. Goody is not admitting the conduct. However, she acquiesces and acknowledges that if this case were to go to a trial, that there is a likelihood that a reasonable jury of her peers could find her guilty. This court also sits in a very unique position in this case, because a lot of times these cases take place in front of the district court and they have the transcript. They have the transcript of the preliminary hearing. However, they weren't there and they didn't observe it live. In this particular case, this court sat in judgment at the preliminary hearing. And so I listened to the folks testify. I could glean their body language. I could glean and make interpretations of the credibility. One of the things that my predecessor does that I really appreciate, Judge Carnaroli, who normally sits in this seat, he goes over the factors that are enumerated in Idaho Code Section 1925-21 as to whether or not an individual should be placed on probation or whether or not a jail sentence is appropriate. I'm just going to go over them briefly. Following factors, while not controlling the discretion of the court, shall be accorded weight in favor of avoiding a sentence of imprisonment. And here we're talking about jail, not imprisonment. The defendant's criminal conduct neither caused nor threatened harm. Well, that doesn't weigh in your favor, Ms. Goody. Your conduct here is you acquired selenium in some fashion and you were administering it. You admitted it. The defendant did not contemplate that his criminal conduct would cause or threaten harm. Well, the evidence that was submitted at the preliminary hearing that I reviewed and the information that the court has reviewed in conjunction with this is that you may not have intended to kill Mr. Goody. In fact, I don't necessarily believe that you intended to kill him, but there was evidence that was submitted that would support the fact that you wanted to make him sick so you could take care of him. The defendant's criminogenic needs indicate that the defendant would benefit from supervision and treatment in the community. You'd benefit from that. There were substantial grounds tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. Mr. Smith has done an outstanding job on your behalf, Ms. Goody, of coming forward and bringing information to the table to excuse or justify your conduct and establishing a potential defense in this. A victim of the defendant's criminal conduct induced or facilitated the commission of the crime. The court didn't hear anything with regard to that today. The defendant has compensated or will compensate the victim of his criminal conduct for the damage or injury that was sustained, provided, however, nothing in this section shall prevent the appropriate use of imprisonment and restitution in combination. You have indicated that the plea agreement calls for a payment of restitution. However, the court has no idea, as we're sitting here today, what that restitution would be and the likelihood of your ability to pay it. The defendant has no criminal history of prior delinquency or criminal activity or has led a law-abiding life for a substantial period of time before the commission of the present crime. The court will note that it is not aware of you having any criminal history at all. The defendant's criminal conduct was the result of circumstances unlikely to recur. That one is questionable in this court's mind. You've been caught. The character and attitudes of the defendant indicate that the commission of another crime is unlikely. And the defendant demonstrates amenability to treatment.
Judge, if I might, and I'm so sorry on that last one, I failed to indicate to the court that Ms. Goody has been, ever since her release, has been involved in getting weekly counseling. She has an assessment that she's already done and has worked through. We're not suggesting that she doesn't need to get another one if probation, the court wants to order that, but I don't think I told you that she had been very proactive in doing that and has been doing that for the last year and a half.
All right. Thank you, Mr. Smith.
To your last point.
Thank you. The following factors, while not controlling the discretion of the court, shall be accorded weight in favor of a sentence of incarceration. There is undue risk that the period of suspended sentence or probation the defendant will commit another crime harmful to another person. That, in this court's opinion, is a pretty speculative item. A lesser sentence will depreciate the seriousness of the defendant's crime. That's one that this court is taking very seriously. Imprisonment will provide appropriate punishment and deterrent to the defendant. Imprisonment will provide an appropriate deterrent for other persons in the community. And the defendant is a multiple offender or a professional criminal, which does not apply to Ms. Goody's case. Ms. Goody, in preparation for today, I reviewed a lot of material in preparation for today. You had a ton of people submit letters on your behalf that speak highly of your character. A lot of people are in your corner. The court was hopeful. Obviously, the court didn't realize coming into today that an Alford plea was contemplated within the terms of a plea agreement. The court was hopeful that you would come in and own it today. I know why you didn't. Your attorney has done a very good job by you by reducing this from a felony to the misdemeanor level, limiting your exposure. He's made great arguments on your behalf. But the court was hopeful that you would come in today and own it. The evidence that was submitted at the preliminary hearing, when I went back and I listened to it, the court does not buy the explanation with regard to Mr. Goody having the selenium in his system was a result of THC usage. The court does find that you admitted that you were poisoning him. The court is not completely satisfied as to today's date as to why you were doing that. The court doesn't necessarily believe that you were intending to commit long-term harm, but there was some other underlying reason. But instead today, what I heard from your counsel, and that's at your direction, and which is the very nature of an Alford plea, are arguments of why this court should, why you should be acquitted of the charge. And if that were the case, you should have went to trial. Once again, an Alford plea stands for the proposition that you're not specifically admitting the conduct, which would be similar if you hadn't have taken the stand. However, that there is a likelihood that a jury could have found you guilty given the evidence, and I have to agree with that. And given that those factors under 1925-21 subparen 3, I feel as if I just placed you on probation, ma'am, that it's depreciating the seriousness of the crime that was committed. And I also feel like it is not a deterrent for other persons in the community for similar conduct. So, what the court is going to do, I'm going to enter judgments of conviction as to both batteries. What the court is going to do is the court is going to run the sentences concurrently. Court is going to order you to serve 180 days. Court is going to give you credit for the 9 days that you have already served. I'm going to enter a fine of $500. I'm going to enter the mandatory court costs. This takes into consideration, to some degree, the fact that you were on house arrest for a period of time. You are going to be remanded to the county sheriff's office today to begin your sentence. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Judge, just a quick question of clarification. I assume when the court indicates the taking into consideration the 120 days, are you suggesting because you ran them concurrent with a single 180-day sentence?
That's correct.
Okay, I just wanted to understand that.
Court's in recess.
Thank you.
All rise to the court.